issues in Louisiana family law. I don't think we've had any major new legislation or major developments since the change to Article 134, which increased the factors for best interest of the child by 2, and we'll talk about that a little later. But what we've noticed this year and what's been reported to us this year, both to myself and other professors of family law at the Law Center, is that COVID-19 has had an impact on 2020 in the realm of family law, as it has had an impact on everything else. And what the courts are noticing is that there's an uptick or increase in 3 areas, well, actually 4 areas, but the 3 main areas are domestic violence, tutorships, and interdiction. And so this morning, I'd like to discuss those upticks, what the courts are seeing, what they're advising attorneys to do, or what they're saying attorneys are not doing that we need to be doing, so that we can provide our clients with effective representation. So the information that I'm providing you, again, as I said, is based off the local courts. It's probably 18th, 19th, 21st, some of the district courts in New Orleans, and a few other places, Opelousas, Lafayette area, where some of the professors and myself have reached out and just asked questions. And overall, these are the areas where we're hearing that there are changes and upticks in cases, and what COVID-19 is doing to the family court arena or the family law arena. So I have a few notes here, and I'm going to fill them in. And if anyone has any questions, I guess raise your hand in the chat, or you can, at some point, I'll pause and ask for questions, and I'll try to have as much of an interactive discussion as we can, and I'll provide as much information as I can. So all of the courts are reporting increased numbers in instances of domestic violence and decrease in prosecutions, or decrease in the ability to prosecute the cases timely. I guess you would say that the cases are lagging because of COVID-19's effects, and the ability to actually get people into the courthouses and prosecute these cases has been limited. A lot of that is going on now, but of course there have been interruptions in court hearings and court cases when there have been surges or spikes in COVID-19. I know that here locally, we've had a couple of instances where the courts have had to suspend their hearings and procedures because of COVID-19. So that's increased delays. One of the interesting, effects of COVID is that there's been an increase in the filings of requests for both tutorships and interdictions. And those aren't things, they're commonplace, but they aren't things that the courts see as many of as they're seeing now. And one of the concerns is that the attorneys handle them properly and be very aware of what the law is. So I'm going to spend a few minutes today talking about tutorship, some emancipation issues, and as well as interdiction. So having said all that, I'll keep it moving and tell you what they're telling us. Of course, we know that domestic violence is a big issue, and it's affecting several areas of the law. One of the problems that many of the courts are seeing is that because of issues with homelessness and evictions and foreclosures, domestic violence incidents are increasing, and people are staying in those situations because they don't have anywhere to go, or because of unemployment situations, or whatever other impact COVID-19 is having on their ability to make different decisions. So the courts are seeing increases in not only petitions for protective orders, but also increases in divorces based on Louisiana Civil Code Article 103, particularly sections 4 and 5, which provides grounds for immediate divorce, or immediate grounds for divorce, when there are instances of physical and or sexual abuse involving the spouse or a child of the marriage, and when a domestic violence protective order has been issued against one of the spouses. And so what the courts are saying is that we're having more instances of filings based on those provisions, sections 4 and 5, but that often the attorneys aren't realizing all of the ramifications or potential consequences involved with filing under those provisions. And so I'd like to spend a little time this morning to talk about those provisions and what they mean and what type of impact they can have in your handling of those cases. Of course, those areas affect incidental matters like spousal support and child custody. So we'll have a little discussion about the impact of domestic violence on spousal support and child custody issues as well. So just because I am a purist at heart when it comes to the code, I'm going to just read exactly what the code says when it comes to Article 103, subsections 4 and 5. And subsection 4 says that during the marriage, the other spouse physically or sexually abused the spouse seeking divorce or a child of one of the spouses, regardless of whether the spouse was prosecuted for the act of abuse. So subsection 4 allows an abused spouse or an alleged abused spouse to file for divorce based on physical or sexual abuse against themselves or one of the children of either of them or a child that they have in common, based on those domestic violence allegations. The case does not have to have been previously prosecuted, but the spouse has to be able to prove that the instances of domestic violence occurred. This differentiates from subsection 5 because in subsection 5, the code says after a contradictory hearing or consent decree, a protective order or an injunction was issued. So this means that the person has gone to court, obtained a protective order or some type of consent decree to a protective order against the other spouse to protect that spouse from domestic violence. They also can file for a divorce based on this. So these two provisions play a role in incidental matters, and the courts are saying in some instances the attorneys are not prepared to deal with the potential ramifications. So that leads to a discussion of spousal support and child support. So spousal support is covered in 112 and 113 of the Civil Code for those of you who do not do a lot in family law. And this is kind of an overview. Some of you will find it very boring because you practice a family law on a regular basis and you are in and out of the various family courts, and this is commonplace. But because of COVID-19 and because of the negative impact it's having, a lot of attorneys who are competent in this area but have not practiced in a while are missing some of the nuances, and the courts are asking, or rather requesting, that attorneys bone up on these nuances and be prepared to discuss and dispense with these issues, as their time is very limited now in light of COVID-19. So one of the issues that was brought up here locally was spousal support and the rebuttable presumptions that are created. So before I get into the rebuttable presumption, everyone knows that spousal support was previously called alimony in Louisiana, and there can be a determination of interim spousal support and then periodic or final periodic spousal support. So the courts are requesting that competent attorneys be aware and be prepared to discuss and advocate on behalf of their clients or defend their clients with regard to the rebuttable presumption that is involved when there's domestic violence in these instances. So again, because I'm a purist, I'll go to the code and just kind of run through it because it's very clear in the code what the interim allowance and the entitlement of a final award in with spousal support, what they are and how they may be extended and what's the causes and what factors are involved. And the courts are saying that because of the lack of preparation or the lack of an awareness about the domestic violence provision and the rebuttable presumption thereto, many of the claimants or clients that are coming before them are not being fully serviced by their attorneys. So I know that's not any of us, and I hope that hasn't been me, but just to bring your attention to it. So, of course, interim spousal support is a different animal. It doesn't create any type of rebuttable presumption. But I'd just like to talk about it for a minute for those who maybe do not practice as much family law as others. So in a proceeding for a divorce or thereafter, the court may award interim periodic support or may award final periodic support to one who is in need and the other party who has the means. The lifestyle of both parties are considered. So when you look at interim spousal support, there isn't really a determination, well, not really, there isn't a determination of fault or whether you are free from fault or not. It's based on the need for support and the other party's ability to pay. So there isn't a rebuttable presumption there. But one of the things that another nuance that the courts want parties to be aware of is that spouses cannot waive interim support in any type of agreement. They can waive, of course, final support, but they cannot waive interim allowances. But with final support, the person requesting the support needs to be free from fault. So in an instance where a person has been accused of domestic abuse or a divorce has been granted because of domestic abuse or a protective order has been granted because of domestic abuse, there's a rebuttable presumption, and it is rebuttable, but there's a rebuttable presumption that the person who committed the act of domestic violence or who's been found guilty of domestic violence is at fault for the divorce. And unlike in other instances or other grounds for divorce where spousal support is capped at 1/3 of the paying spouse's net income, a 103(4) or 103(5) or subsection 4 or subsection 5 divorce does not have such a cap. So the paying spouse may very well have to pay more than 1/3 of their net income when the divorce has been granted based on domestic violence. The courts are saying that sometimes we miss this and that it often results in bar complaints and allegations of malpractice when an obligee has to pay, obligor, has to pay 1/2 of his income because he or she entered in a consent decree with regard to a protective order for domestic violence, and they weren't able to overcome the rebuttable presumption at the hearing. So this is just like food for thought for you to think about the fact that sometimes you have to be sure that you are representing your client to the fullest and that you are asking for all of the information before you decide on which route you're going to take to represent your client. So just another aside. Sorry, I kind of moved ahead a little too fast. Let me go back. So with regard to the final periodic support, if you want to take a look at this or take a look at some of the cases that are involved with this, of course, you can always see the Wascom case. It deals with spousal support. And then the, sorry, I'm looking at my notes, y'all. Bear with me 1 minute. The Louisiana case, and I can provide the sites for these cases. If anyone would like to have them, I can provide those. but the courts are talking about when there's a determination that a party or a child of one of the spouses was victim of domestic abuse committed by the other party during the marriage, the sum awarded may exceed 1/3 of the obligor's net income and may be awarded as a lump sum. So the courts can either order some periodic support over a certain period of time that exceeds the 1/3 threshold, or they can also order a lump sum award when looking at those factors. Now, of course, this does not mean that the court does not consider the relevant factors to determine the amount and duration of final support, but it does mean that the offending person, if they've been convicted of domestic abuse, they have a heavier burden to bear because the courts are going to look at those factors less favorably on their end. So, again, just another consideration when you start to talk about spousal support in light of the uptick in domestic violence cases, the uptick in filings for divorce based on domestic violence, and then dealing with the incidental matters, one of which is often spousal support. And this particular issue was specifically mentioned when we were inquiring about current trends and upticks. Another issue, of course, with domestic violence is child custody issues. It has a negative impact on custody of the minor children, and the courts looked, of course, not favorably, but will consider acts of domestic violence when a child has witnessed the acts or privy to information with regard to the facts, even if the child has not in fact been physically abused. So I may not have said that clearly. What I'm saying is if a child is living in a home where abuse occurs, the perpetrator of that abuse will be held to account for his or her actions and the potential impact that it has had on this child, even though that perpetrator may say, I have never physically abused my child. There are other forms of abuse, emotional, mental abuse that may come into play with these type of cases, and that is also looked at when considering the best interests of the child, in particularly at Article 134 of the Civil Code, which we will talk a little bit about. In 2018, there were changes to the best interest of child factors that are listed at 134. The courts kind of cleared up the legislature cleared up in their mind some ambiguity with regard to child abuse and the stability of the home environment. And so if you have a copy of your code and you're following along, if we're going to look at it a little bit later, I would draw your attention to factor 6, the permanence as a family unit of the existing or proposed custodial home or homes. This factor has been amended in order to state what is believed to be the better rule of the much litigated issue addressed by it. Previously, it simply read the moral fitness of the parties involved. And then, so this language has been added to bring it in line with the fundamental principle that the purpose of every custody award is to secure the best interests of the child, and not to regulate the behavior of its parents. Now, previously, that has been looked at as if their parent has some moral issue, adulterous behavior or so on and so forth, like the Stevenson case, or Baggett versus Baggett, where the parent was in a relationship and had overnight guests. The courts have previously said, we don't look at these things as having a detrimental effect to the child. But what we do look at as having a detrimental effect to the child is if the child suffers some type of physical, emotional, abuse based on the actions of the parent. So that's the change in factor 6 of this article. And then there's also a change. I'm sorry, I'm looking at my notes. Also a change with regard to clarifying what the potential for abuse is. So factor 1 says the potential for the child to be abused as defined by the Children Code Article 603 is a primary consideration. And then it goes into the other 13 factors. But the legislature has gone to a great deal or made a great deal of effort to clarify that abusive situations where the child has been privy to domestic abuse, but not necessarily suffered physical abuse, does not mean that the child has not suffered some detriment as a result of the acts of the perpetrator. And this is being used to make determinations for custody. And so oftentimes persons who may have been eligible for shared or equal custody, where they would have had the children 50% of the time, are now being relegated to joint custody, where the perpetrator has joint custody with a visitation schedule that's less than 50% of the time because of what the child has seen or witnessed at the hands of that parent, or because there's a need for counseling or some type of rehabilitative counseling, or time for reestablishing of the relationship with the parent in order for them to exercise custody because they've been the perpetrator of domestic violence that has been detrimental to the child in some way, even if the child did not suffer any physical abuse. So these things are playing a role in custodial determinations as well. Oftentimes, parents who are perpetrators of physical abuse against their children do not have any type of custody if the parent is shown if the parent is able to establish that the person did perpetrate an act of physical abuse against the child. And they will not have any custodial rights. They may have visitation rights or some type of supervised visitation schedule, which would lead to the other parent having sole custody. So I have this little chart here about the custodial options available. And again, for those of you who practice family law a lot, this isn't gibberish to you. You're very familiar with it. But just to kind of go into it, the preferred custodial option or custodial arrangement is joint custody, where the parties either agree to joint custody or the courts award joint custody of the child to both parents. There can also be shared or equal custody where there are minimal best interest issues and the parents are both suitable to share custody, and they can work out some type of schedule where the child is spending 50% of his time with both parents, or each parent is getting half and half, whatever the case may be. Sole custody awards are often given when there's a clear and convincing showing that it's in the best interest of the child that only one parent be awarded custody. And the other parents, again, may be relegated to some type of visitation schedule or supervised visitation, depending on what the circumstances are. Of course, there can be custody to a non-parent if it's shown that substantial harm will result if the child is in the custody of either parent, and that it's best that the child be awarded to another person, that custody be awarded to a non-parent. So just to kind of go through those things briefly and to say the effect that they may have on custodial awards. So again, domestic violence, because of the increase in instances of domestic violence, is having a direct impact on what's going on in the courts, how the courts are deciding these cases, and whether or not parents are being held to account or held to task for incidents involving domestic violence when divorce is based on either subsection 4 or 5 of the Code or Article 103. Another area that is being affected by COVID-19, or where there's been an uptick in cases that the courts generally do not see, have been applications for tutorship. I'm sorry. If you are not, again, if you're not one who is constantly practicing in the area of, in the family law area, tutorship provisions, you probably haven't visited those since law school. And so the courts are asking that we advise the bar and advise our colleagues to bone up on tutorship, and in some instances, applications for emancipation, because of uptick in these types of cases. So the code provides that a minor who is not emancipated is placed under authority of a tutor after the dissolution of the marriage of his father and mother, or the separation from bed and board if it's a covenant situation. So the courts are saying that because parties are now requesting more divorces based on domestic violence, and there have been more instances where most times the domiciliary parent, or the person who the child spends most of their time with, is considered to be their natural tutor. But because of the situations that have been highlighted with, again, homelessness, with the uptick in evictions and foreclosures, and children having to live outside of their custody of their parents and maybe living with relatives, there have been an uptick of tutorships and requests to have persons other than the natural tutor, who was the mother or the father, placed in the place of or given tutorship. So that was kind of a tongue-tie explanation, but I will get into it a little bit more. So if you're unfamiliar, you should go back to Louisiana Civil Code 246 and start there. 247 outlines the four sorts of tutorship. So there's tutorship by nature, which is just natural tutorship. And then there's tutorship by will, which we'll discuss a bit, because there have been some instances where parents have been diagnosed with COVID-19 and had to seek medical care for themselves, and unfortunately they passed. There's one case pending right now where the parent actually tried to appoint a tutor for their child prior to their passing, and there's some issues with it, and I'll kind of give you some of the facts for illustrative purposes or illustrative purposes, so that you can kind of wrap your head around what happens when you have a tutorship by will. And then there's tutorship by effective law. And then there's the dative tutorship, or tutorship by the appointment of the judge. And so the courts are asking that attorneys familiarize themselves with the type of tutorships available, in light of the fact that there have been more requests for tutorship, and that we prepare ourselves to navigate through these various types and provide the courts with the necessary information to be able to make a ruling more quickly, considering the lag time that COVID-19 has caused. So tutorship by nature takes place by right, and the natural tutor may have to qualify for the office as provided by law. Now, usually when we see a qualification for tutorship, when there's a natural tutor, it's usually involves some type of personal injury case, or at least that had been my experience with tutorships when I first started practicing law. And as we started to go through the practice, we would ask for tutorship appointments because the parents were involved in some type of suit and needed to be confirmed or appointed as their child's tutor to pursue the case. The courts are seeing that in a different light now because of COVID, and different instances because of COVID. And so they want to have us bone up on this issue and be prepared to understand that a person may be entitled to tutorship of a child and need to be confirmed or appointed by the court, even when they are tutor by right, when the parents have dissolved the marriage or have separated because of not only domestic violence issues, but because of the issue of losing their home, and some of the family has to stay at place A and another parent has to stay with some of the children at place B. And now they're coming to courts because they need to get the kids enrolled in different schools in different places. And they're not just asking for custodial issues, they are also asking for tutorship for various reasons. Now, the courts are saying in some instances, there's no need for a tutorship. But if they are going to be administering the property of their child or some type of trust for their child while they're separated from the other parent, then there is a need to have what we would call a natural tutor confirmed or appointed by the courts. And when we don't get those things done, or we don't file the proper or necessary paperwork to do so, there's a lag that often serves to the detriment of the child. There's also a need for a person who's requesting tutorship of a child to understand that they are responsible and accountable for whatever happens to this child or child's personal property while they are the tutor, or if they're handling an estate for the child, they are responsible for the child's estate. And they need to be very sure that they have the ability to administer the estate, or that they will have the necessary assistance and support to do so. So Article 250 kind of outlines the tutorship. And so I have this here only so that you can know that you can go to Article 250, and it will explain that if one of the other parent dies, then the right of tutorship belongs to the other parent. If there's a divorce or a judicial separation of the parent, the tutorship for each minor child belongs of right to the parent under whose care he or she has been placed, or to whose care he or she has been entrusted. Usually, if there's an award of joint custody, then they will have co-tutorship, but with equal authority. But if the courts find that they need to modify that because the child is spending more time with one parent versus the other, or does not have contact with one parent more than the other, or if there's a sole custody award or a custodial award to a non-parent, the court will modify and adjust that tutorship award accordingly. So again, these are all cases of tutorship by nature, but Article 250 explains or outlines how those tutorships may occur unless they are modified by court order or by agreement of the parents, or if there's a person who's been awarded custody and they are a non-parent, the court may deviate from that. So there are tutorship provisions at Articles 252 and 256 that kind of cover they cover the instances when there are children, posthum unborn children, or children born outside of marriage is Article 256. And then Article 257 covers tutors by will and the right to appoint tutors, along with Articles 258 and 259. So I mentioned earlier the right to appoint tutors by will. And so I'd like to talk a bit about that, because that's some of the pending litigation that the local district courts are seeing right now. And one instance particular with a mother who had a will prepared prior to her death, or prior to being incubated with or placed on a ventilator, and she subsequently passed. And she had prepared a tutorship appointing a relation as the child's tutor. But the child's father is still alive, or is still alive. And the courts denied the right for her to appoint a tutor. And it was done by authentic act because there was still a father alive. And the code clearly states in 257 that the right to appoint the tutor belongs to the parent passing last. So the father had the right to appoint a tutor because he's the child's last living parent. But in this particular instance, the father was not involved in the child's life, had spent a significant period of time incarcerated and had been recently released and had not reconnected with the child. And so right now the child has property that isn't being administered because his father has, of course, the right to appoint a tutor, and in not appointing a tutor and his mother's passing, the child, who was formally acknowledged by the father, is under the tutorship of the father. And the family who's involved does not have a means or the ability to contact him. So the child is kind of in a limbo situation. And because it requires more than one hearing and the lag time in between hearings and the impact of COVID, the child has now, I think the court says, been 5.5 months without a tutor, and they are struggling to get things in place because of constant interruptions in the court system in light of COVID. So just another, I guess, quirk in the system. But the preparation of the will, when the mother was prepared her will prior to passing, didn't take into account that upon passing, if there is a parent alive, she was not in a position to appoint a tutor, and did not take any consideration as to how the father would be contacted or what would happen in the interim of trying to establish some type of contact with the father. So that's one of the issues that they are grappling with right now. What happens next? So that's looking at 257 and 258. So just if you're ever in a situation where people are coming to you to be appointed tutors or to have some type of attestation done to appoint tutors, make sure that you're very clear about their ability to appoint and that they have options available to them, or that they make plans in the event that they are not the last surviving parent, because they don't have the option to appoint by will when they are not. Tutorship by the effect of law is just basically looking at the priming order that the court will look at when appointing a tutor for a child. If they have to look at relationships, which is what's happening with this particular child, pending finding his biological father who formally acknowledged him, they probably are going to appoint some type of interim tutor for him, but that's going to require another court hearing. A dative tutorship comes into play when a child is a minor and there hasn't been an appointment of a tutor by his mother or father, and there aren't relations readily available to act as his or her tutor. So that's a different instance, but the courts are saying that they're seeing a lot of cases where children are being left orphaned because of COVID-19 or because of other circumstances. And now people are petitioning the court to have tutors appointed more so than they have in the past. Of course, for every tutorship, there has to be an appointment of an under tutor. And the duties of the under tutor are at the end the same as those of a tutor. He has the same level of responsibility to his charge, and to make sure that they are able to account for their handling of the administration of the child's estate. Does anybody have any questions about that? I know it was a bit jumbled, but I'm trying to give you instances of what we're seeing or what we're hearing is trending in the courts, and what the courts are asking that attorneys prepare themselves to do with regard to preparing for these inevitable situations. It's very hard to prepare for the inevitable, but they are asking that the attorneys come prepared with options, because a case that would have been continued for 2 weeks now may be continued for 2 months because the courts aren't able to litigate these cases quickly. Yes, sir, Mr. Armistead, am I saying that properly?
Mr. Armistead, you can unmute yourself.
Okay. Say in a situation where the father's incarcerated, he hasn't had any time with him, and the mother gets sick, can the father waive his rights to tutor, or do you have to do a termination of parental rights?
That's a good question. I don't think you have to waive your right to, I don't think he has to terminate, his parental rights don't have to be terminated, but I do think that he can appoint a tutor to act in his stead since the mother has passed. The problem with this particular case, or the case that I'm mentioning, is this father was released from his incarceration as a result of COVID, and they have not been able to locate him to get him to provide any guidance as to how he would handle the child's estate. And the child has inherited as a result of his mother's death. So right now, the court is saying it wasn't handled properly from the initial filing. And so there's been a lag time of about 4 or 5 months now with getting the matter back into court. So I'm not sure what's going to happen with it, but I don't think his parental rights would ordinarily need to be terminated. He could have just appointed someone to act in his stead while he's incarcerated.
Well, my issue is to preempt that. If you know he's incarcerated and you want to do something now by a will, say you're a parent, you don't have contact, but you have a other relative, can they do that through a will prior to their death and get the other person to join in?
Right. So in this particular instance, her better course of action, or like you said, to preempt this, would probably not have been to do the tutorship by will, but probably to place the child under someone's legal guardianship or custody, but that was not done. So there are ways to preempt it, but in this particular instance, they did not. They chose to have her execute a will rather than have some type of she could have done some type of guardianship, some type of temporary custodial arrangement, but they didn't do that. So these are the types of instances that the court is saying that the attorneys need to be more familiar with the provisions of tutorship, because that wouldn't, tutorship by will wasn't the appropriate mechanism.
So if she had terminated his rights prior to doing the tutorship by will, then the will would have been effective.
Yes, if his parental rights had been terminated prior to her passing, yes.
So a lot of times, if you just know that this is not going to work and it's early in the game, then go ahead on and I guess file a motion to terminate your parental rights and then do a will, and that covers you later down the road.
Right, because in that instance, she's the only parent with any type of custodial authority. In this particular instance, she had not done anything prior to her passing to terminate his parental rights. And now they're unable to locate him. So a child has they need to get some type of interim guardianship or something done, and that hadn't been done. The court was frustrated by the fact that the attorney chose to have the parent execute a will rather than taking another means of getting this done.
Okay, thank you so much.
I hope I clarified that. I'm not sure.
Oh, you did?
Okay.
I appreciate it.
Okay, all right. So just one of the instances where COVID-19 is playing a role. I mean, in this particular case, she sought legal counsel before agreeing to to be ventilated, to my understanding, and they chose to have her execute a will. And the courts are saying that was the wrong move, and that attorneys need to be aware that that may not be the best move for their clients. So I wanted to bring that instance up as one of the trending topics. Another issue that the courts believe is directly related to the COVID-19 pandemic is an uptick in the requests for interdiction proceedings. Again, when you think of interdiction proceedings, you usually think of elderly persons who are unable to care for their person or consistently make decisions with regard to their persons or property. And that's exactly what interdiction is. But now, in light of COVID and the inability to have nursing homes or to find that nursing homes are a safe alternative for some of the elderly, a lot of people are trying to pursue interdictions so that they can take over the handling of their parents' estate without using nursing home, or even sometimes they're not necessarily their parents. They may just be relatives who now need assistance, or they feel need assistance, and the assistance that was available to them prior to the pandemic is no longer available. So another area that the courts are asking us to bone up on is to understand that a full interdiction is not a civil commitment. A civil commitment requires compliance with standards and procedures that are set forth in mental health law. And that's outlined in revised statute title 28. So interdiction is not civil commitment. And a petitioner in a full interdiction proceeding has to prove by clear and convincing evidence all of the facts that justify interdiction. And that's outlined in the Code of Civil Procedure at Article 4548. But I want to just talk about Article 389 of the Civil Code and its effect and what's required for full interdiction. So again, going to the code, it says that a court may order the full interdiction of a natural person of the age of majority or an emancipated minor who, due to an infirmity, is unable consistently to make reasoned decisions regarding the care of his person and property, or to communicate those decisions, and whose interests cannot be protected by less restrictive means. So I don't have less restrictive means on my little slide for whatever reason, but the courts are looking at unable to consistently make reasoned decisions, and whether those decisions affect their person, their property, or both. It has to be proven by clear and convincing evidence. So they're saying a lot of the filings that they are seeing is that the person is saying that my mom is elderly and she's unable to make informed decisions consistently, but she's not suffering from an infirmity. She's simply getting old, for lack of a better term. If there isn't an infirmity involved, then the courts are suggesting that you find more practical means of taking control of your parents' estate, or in this instance, as a lawyer, you advise your clients differently about taking over their estates. And one of the easiest means of doing that is a power of attorney. Now, when a parent does not want to give you a power of attorney, then that's a different instance. And you may have to file for an interdiction proceeding, but you may not need a full interdiction. You may need a limited interdiction because the parent is very well capable of taking care of their person. And it's just that they're not able to go about taking care of their property. They're not able to make sure that they are able to get out and do some of the things that are required of them. I can't think of an example right now, but maybe they have mobility issues and they're not able to get out and about as much, but they are in their right mind and they're able to take care of their person. Well, then the attorney shouldn't try to get full interdiction over this person. They should try to find the least restrictive means or the lesser of restrictive means so that they can come to some type of, again, agreement or actually get the type of interdiction that best serves the person's interests. The courts have been dismissing a lot of these because persons are coming asking for full interdiction and then the person that does not suffer from an infirmity that prevents them to consistently make reasoned decisions. So I wanted to bring that up as one of the issues that's coming up that the courts are seeing, and they're saying that attorneys are not handling them properly. So we always want to make sure that we are handling things properly and that we are getting the desired outcome. And oftentimes in interdiction proceedings or in a successful interdiction proceeding, it's not going to just be your client. You are going to have clear and convincing evidence that this is a last resort and that it's warranted because there aren't any other reason or any other way to protect their interests. And that usually involves support through medical documentation or support services that the person may have been using as a result of their infirmity, who can now categorize that infirmity as affecting his functional ability, and that it's stopping him or her from making reasoned decisions. And usually that's not going to just be the testimony of one person. So there's a lot involved with having a person determined to be an interdict, and especially at a full capacity, because it's so very restrictive. So courts want us to be aware of that and to not misuse those proceedings. So again, just another example of one of the things that came up a couple of times in various districts, that there's an uptick in filings for interdiction, and that the requests do not meet the requirements of law. And the problem with requesting interdiction and not meeting the requirements of law is that the person who files for an interdiction, they may be liable for damages caused if they knew or should have known that the request didn't rise to the level of scrutiny that they were asking the court to place on this person. So, for example, if you request an interdiction for your parent and the court places them under a temporary interdiction until they can have a hearing, and then at the hearing it's shown that the petitioner knew or should have known that the factual allegations regarding this person's ability to make decisions were false or did not rise to the level of placing such restrictions on them, could very well be liable to any damages suffered by the person while they were under a temporary interdiction. And that's in the code. Let's see where it is. It's in the code at Article 399. So that's the other reason why you have to be very careful when you decide to pursue an interdiction action or an interdiction proceeding, because of course you're going off what your client is telling you or the petitioner is telling you, but those things need to be corroborated, because when your client is found liable, he or she may decide to make you liable for the damages suffered by the person, because my attorney didn't tell me that. My attorney told me to file for an interdiction, and you might find yourself in the middle of a malpractice issue if they are liable for some loss that the proposed interdict suffered. And then last thoughts, I think my time is winding down, but last thoughts with regard to things from around the district, just things that the courts are saying in light of COVID-19, is that they would like for attorneys to be open and available for telephone status conferences and Zoom conferences, etc. There's attorneys want to come into the office. They don't want to do telephone statuses. They don't want to do Zoom conferences. And courts are saying, in light of the situation and the fact that this virus is easily transferable, these type of services are what's making it possible for them to continue to serve the public. And that when people don't adhere to it, it makes their job overly burdensome. Then when you agree to the Zoom conference, practice using Zoom and its features, because oftentimes they agree to a Zoom conference and then you have an issue where they aren't able to log in, they aren't able to participate. And it slows the court's docket down, or it slows their ability, it causes them to have problems providing the services that are needed. Practice document and file manipulations for e-filing and court submissions. This has come up because a lot of the filings with the clerk's office have been gone to e-filing and submitting documents when the courts have requested that they be filed into the documents, and the attorneys are not able to do it successfully. They're having problems with getting the documents in where the court can process them. So they are asking that we practice document and file manipulation for e-filing and court submissions. And file only what's necessary. Of course, saying a lot of frivolous filings, and the concern is that when they are dealing with those things that are not as serious as previously indicated, that they are losing the opportunity to service people who have more urgent needs. So one of the things that early on, there are a lot of filings about custodial visitations being interrupted because of COVID-19. And a lot of parents were responding with, well, because of the lockdown, because of this situation, I have not been able to arrange for a custodial exchange, or I'm afraid to participate in any type of custodial exchange because I don't know what's going on with my child when he's over at parent B's home. Some of them were, of course, excessive interruptions in the visitation that needed to be handled, but other filings was because I didn't get to see my child last Saturday and I was supposed to spend 4 hours with them. And the courts are asking that attorneys temper this and address those issues that need addressing, and try to mitigate or mediate the other issues. Be prepared to try your case electronically and remotely. One of the other issues the court said they're having is that they have prepared case or set cases for hearing remotely, and the attorneys show up at the office saying that I can't try my case electronically. I need to be able to hand you the paper. I need to be here in front of the witness. This is looking at them, questioning them, and the courts are saying if that's so, then you need to prepare and practice to try your case electronically, or stop setting trial dates if you know that you are not prepared to try your cases in this manner. Lastly, which I thought was kind of strange, courts are asking that the attorneys take safety precautions. So oftentimes the attorneys are coming to the offices, they're not wearing masks, they have masks, they wear the mask to get in the building, and then they're no longer wearing the mask when they get to the courtrooms or to the judge's chambers or whatever the case may be, or when they get to the clerk's office, they've removed the mask. And oftentimes support staff is uncomfortable asking attorneys to wear their masks. So please take necessary safety precautions when you're entering these buildings. I know I was just told recently that the family court just recently had to shut down because of a COVID-19 surge among some of their staff and personnel. So this disease, if you're watching the news, of course you know this, it's still surging. It's still, there are still hot spots, and the numbers are growing daily. So the courts are asking that you take the necessary safety precautions, that you practice using the alternative means of forwarding and pursuing your cases, Zoom and whatever other type of electronic and remote options available to you. I think that's all I have. And if you guys don't have any other questions, I believe I'm done as far as updating what's going on around the various districts this year.
All right, thank you. Does anyone have any questions? You can raise your hand or use the chat, or use the Q&A button if anyone has any questions. All right, if no one has any questions, thank you, Attorney Grace Obear, for the presentation. Our next presentation will start at